This is one of those courtroom cases that leaves you questioning everything: responsibility, justice, and where the line between accident and negligence truly lies. Today, we're diving into a deeply emotional and legally complex case involving a fatal crash that resulted in a charge of criminally negligent homicide. The defendant, Mr. Vishaw, has already pleaded guilty, but here's where things get intense. Despite admitting responsibility, his defense is pushing for probation instead of jail time. Now, that might sound reasonable at first, until you hear what the prosecution has to say. They argue this wasn't just a tragic accident, it was pure negligence. And as the courtroom unfolds, we'll see conflicting narratives, emotional appeals, and a judge force away remorse against accountability. So here's the big question: can someone admit guilt, show remorse, and still deserve prison time? Or should intent matter more than outcome? Stick around, because this case takes some unexpected turns, and the final ruling might not be what you expect.
Good morning, sir. Are you Vishal?
Yes, ma'am.
And this is cause number 25 DCCR 0507. Mr. Vishal was previously in court, entered a plea of guilty to the state jail felony offense of criminally negligent homicide. This was unagreed. The plea was, I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge. State has, Judge.
Are there any additions or corrections to the report?
Not from us, Judge. Not from the state.
All right, then, Mr. Gertz, you may proceed.
Judge, we're asking the court to consider probation. This case is unique, I would argue, for a variety of reasons. First and foremost, this court is very familiar with me and my proclivities. I would try this case 100 times out of 100. When I walked in to talk to him the first time, he said, I want to accept responsibility.
Right here, something extremely important happens, and if you're not familiar with courtroom dynamics, you might miss it. The defense is emphasizing that the defendant immediately accepted responsibility, which is actually quite rare in serious felony cases. Most defendants fight charges, delay proceedings, or negotiate heavily. But here, we're seeing the opposite. Legally, this matters. Judges often consider remorse and early guilty pleas as mitigating factors during sentencing. It can signal accountability and potentially reduce punishment. But here's the tension. Does accepting responsibility erase the consequences of a fatal mistake? And think about this. If someone admits guilt right away, should that weigh more than the actual outcome of their actions? Or is justice about consequences, regardless of intent? Let me know what you think.
That almost never happens. He didn't shirk his responsibility. We can talk all day about the fog. We can talk about the Tex dot needs to get their act together with the shoulders on the highway, whatever we want to talk about. He wanted to take responsibility. And he said it from the first day. When was the last time you ever saw me come in and plead on the first hearing, plead guilty to a serious offense like this? Never. He wanted to do that. That was him wanting to do that. And so from that standpoint, it's a unique case. The other reason it's a unique case is there's no aggravating factors here. He's not intoxicated. He's not on his phone. He's not doing anything other than driving his vehicle. Now, what happened to these people in the end result is absolutely tragic. And again, he's taking full responsibility for that. But I will tell you, Judge, if he'd had 5 more seconds notice, he wouldn't have been able to stop the vehicle. It had 10 more seconds notice. He wouldn't have been able to stop the vehicle. He's doing the speed limit. He's driving on the highway, and there are vehicles on his left and behind him, and there is a stopped vehicle on the interstate. I mean, there's not a scenario in which maybe the injuries are less, but there's not a scenario in which this accident.
The defense is now painting this as an unavoidable tragedy, almost suggesting that no matter what, this accident would have happened. They're arguing there were no aggravating factors, no intoxication, no phone use, no reckless speeding, just a driver on the road facing an unfortunate situation. But here's where things get legally tricky. In criminally negligent homicide, the key question isn't whether the person intended harm. It's whether they failed to perceive a substantial risk that they should have recognized. That's the legal definition of negligence. So even if everything seems normal, the court has to decide, was there something he should have done differently? Could he have reacted faster? Maintained more awareness? Because in the eyes of the law, tragedy alone isn't enough. There has to be a failure of responsibility.
That does not happen. And so, again, he's saying, I should have been more careful. I could have done other things. I could have fixed this. And the way he's saying that is with his plea and also his statements here. He expresses deep remorse. He struggles to sleep at night. He feels guilty about what happened to these people. And again, there's nothing redeeming about the outcome for these decedents, these victims. But the reality is, this is a situation that is a terrible, tragic accident. He is trying to take responsibility. I think that is, again, at least from my standpoint, is somewhat unique. And I'm asking the court to at least consider the distinct possibility and the option here that you have to grant him deferred adjudication probation. He would give up his driver's license. He'll give up his CDL. He'll do whatever the court orders in order to comply with probation. But putting him in the state jail for another year and a half is not going to fix anything. It's not going to make it any better for these decedents. It's not going to make it any better for their families. It's not going to do anything to anyone other than just cause him to not be out in the world for a year and a half. And that's it. And so this court could supervise him. This court could oversee his continued acceptance of responsibility and also protect the public at the same time. So we're asking the court to consider doing that, and that is our request.
All right, thank you. Mr. Coleman?
Thank you. I'll be brief.
Are there any holes? No.
I'll be brief, Judge. Mr. Gertz and I agree on one thing, that I, like him, would try this case, as he puts it, 100 out of 100 times myself, Judge.
And just like that, the entire tone of the case shifts. The prosecution comes in strong, directly rejecting the idea that this was an unavoidable accident. Instead, they call it exactly what the law defines: pure negligence. Now, this is a powerful moment. Why? Because they're introducing video evidence. And in modern courtrooms, video can completely reshape a case. According to the prosecution, the victim's vehicle wasn't even stopped. It was moving slowly with hazard lights on. That contradicts the defense's earlier narrative. So now we have two competing realities, one describing an unavoidable crash and another suggesting preventable negligence. And here's the question for you. If video evidence proves the driver had time to react, does that completely change how you see this case?
This is no accident. This is pure negligence, as it is the definition of negligence. I'll spare the court. I didn't showing the court the video. The tractor trailer that this defendant was operating that day was equipped with dash cam, or a version of dash cam video that shows that the vehicle that he struck was not stopped. It was traveling at a slower speed with its hazard lights on, but it wasn't stopped. There was no fog. The conditions were clear, and there was no cars on the other side of this tractor trailer rig, preventing it from even changing lanes. I have the video. The court, if it desires, can certainly watch the videos. Short clip. But Judge, I take issue with that recitation of how this all went down. I'd like to offer State's Exhibit 1. It's a certified copy of FBI records indicating that
Make
this defendant...
that 2.
Make it 2?
Because State's 1 would have been the plea papers.
Right.
And we have no objection to it.
It indicates, Judge, that this defendant illegally entered this country and he's a national of the country of India. Judge, I'm not here to make some type of a political statement or commentary. I'm just simply saying that it is a violation of federal law to enter this country illegally. And Judge, like any other violation of law, in any other case, you can take that into consideration in sentencing this defendant. And I'm asking you to take that into consideration in this case, Judge.
This is where things become even more complex and controversial. The prosecution introduces a defendant's immigration status into the argument. Now legally, this can be considered as part of a defendant's overall background, but it's also a sensitive and often debated factor. The prosecutor is careful to say this isn't political, but let's be real, It adds another layer of perception to the case. The court is now not just evaluating a traffic fatality, but also the defendant's legal standing in the country. So here's something to think about. Should immigration status influence sentencing in a criminal case like this? Or should the focus remain strictly on the incident itself? Because moments like this can subtly, but powerfully, impact how justice is delivered.
So here's States 2.
No objection. States 2 is admitted.
I also offer States Exhibit number 3, pursuant to a business record affidavit that's been on file. It is a photo of the victim in this case, Judge. 16-year-old victim in the short obituary of her, Your Honor.
No objection.
States 3 is admitted.
Judge, she was 16 years old, Judge. She had, at the dawn of her life, she'll never get to graduate high school, get married, do the things that people do. Judge, you can say today by your verdict just the amount of damage and harm this defendant has caused due to his negligence. I'll conclude with a couple other things, Judge. This defendant went on to continue to live his life as business as usual in California after this accident while the investigation played out. After the investigation and the indictment, it took some effort on the part of our office in conjunction with the U.S. Marshal's Office to track down and locate this defendant. I'm not saying he was intentionally hiding or absconding. I'm simply saying it took a lot of effort by the federal law enforcement authorities to track him down, Judge. And also this business about this name and the alias name and whether or not he goes by no name given or goes by Bishaw. Again, the court can infer whatever the court wants to infer about why an individual would illegally enter this country and use at least one or maybe two different aliases, Judge. I'm asking for the max, and I am frustrated at the fact that all I can ask for is 2 years in this case, Judge. But I'm asking for the 2 years. In this case, I think this case warrants 2 years. Judge, if the court is not inclined to give it 2 years, I'm asking that the court deny the discretionary jail credit pursuant to my motion that I filed under Article 42A559 of the Texas Code of Criminal Procedure, Judge. And lastly, the family.
Say what you just said again?
It's in my motion that I filed asking that the court deny the discretionary jail credit for state jail offenses.
Oh,
it's
okay.
42A559C of the Code of Criminal Procedure, Judge.
Okay.
And lastly, Your Honor, the family's here for whatever it would be for what that's worth, Judge. And I believe that the mother, the deceased, would like to make a victim impact.
Thank you, Mr. Coleman. So it's my...
Now we're entering a crucial phase, where the judge begins weighing all factors before making a decision. And notice what's happening. Even though the defense argues that deportation is inevitable regardless of sentencing, the judge isn't fully convinced that probation makes sense. This highlights a key legal principle. Sentencing isn't just about the defendant. It's about public safety and precedent. The judge is essentially asking, if someone is already facing deportation, does probation serve any real purpose? Or does it weaken the seriousness of the offense? And here's a bigger question. Should courts prioritize rehabilitation, or should they send a strong message about accountability, especially in cases involving loss of life?
Understanding that there is, at this point, immigration hold on Mr. Bishaw, correct?
Yeah, that's my understanding too, Judge.
Okay. So even though it's likely for him to be deported because he's here unlawful, you're asking for probation?
Well, Judge, there's not really another option, right? So I guess the question is, given the current status of our immigration situation, I have no idea how ICE is going to handle this. What an ICE hold means is that if you give him probation, they've got 3 days to come pick him up. And if they don't come pick him up, then he's placed on probation. And what the court can then do is supervise him unless and until the federal government comes and deports him or attempts to deport him. The kind of alternative to that is he can sit and sleep on a cot that we're providing and eat food that we're providing and then be deported at the end of that. With a conviction or a deferred adjudication, he's going to get deported at some point anyway. So it doesn't really, the court, I'm not trying to be difficult, but this court's decision is not going to change the likelihood of his deportation because A deferred will count as a conviction for deportation purposes. A conviction will count as a conviction for deportation purposes. So, again, we're asking the court for probation because of his acceptance, again, of responsibility here in this case.
All right. And I appreciate the acceptance of responsibility. I do. I appreciate, and I'm sure the family appreciates not having to go through a trial and see what they had to live through over again. And so I will take that into consideration. Probation, to me, in a felony case, really of any kind, when someone is here unlawfully, doesn't make any sense. And again, I'm with Mr. Coleman. I'm not here to make a political statement on any of this, but if you're here unlawful and you've committed a felony offense, it just doesn't make sense that I would put somebody on probation where they're potentially still threat to the safety of our citizens. And the no name thing gives me some concern. Also, I feel like that is just potentially an attempt to avoid probably some issues with immigration and some issues with potentially this case. So what I'm going to do, again, I appreciate, and I'm sure the family appreciates not having to go to trial. But I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of criminally negligent homicide, sentence you to a term of 20 months in the state jail prison. You will receive, I will give credit on that for any time that you've been in custody that the law gives you the right to receive. With regard to the state jail credit, I leave that up to the state jail authorities, and I'm going to deny the motion to deny that credit. That will be up to Mr. Vishaw in state jail. With good behavior, he'll get that credit just like everybody else. So I'm not going to deny that. It's based on, always has been based on how you behave in the state jail prison. And so just to deny that, it goes against the nature of that rule and that law, so I'm not going to do that. I'm going to hand you the trial court certification that shows there was no agreement, which means you do have a right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that to determine what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Gertz. Good luck to you, sir. Thank you, Mr. Coleman, Mr. Gertz. Okay. Did Ms. DeLage?
Deal with the matter.
Oh, I'm sorry. Yes. If y'all will have a seat. Mr. Kimler, can you move for a second so they can use that table? You can just have a seat over here and we'll go off the record for.
And there it is, the final ruling. The judge sentences a defendant to 20 months in state jail, rejecting probation despite acknowledging his acceptance of responsibility. This decision reflects a balance between recognizing remorse and upholding accountability for a life lost. The court also made it clear that factors like unlawful presence and concerns about identity played a role in denying probation. However, the judge did show fairness by allowing standard jail credit eligibility, reinforcing that even in tough cases, the law must remain consistent. This case leaves us with some powerful takeaways. Is remorse enough to reduce punishment? Should external factors like immigration status influence sentencing? And most importantly, how do we define justice in cases where intent and outcome don't align? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts and comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
The victim impact statement.